दिस इज द शॉर्टेस्ट पॉसिबल समरी। जो समरी मैं यूज करने वाली हूँ ना, आप हर बार ये वर्ड जब मुझसे सुनोगे तो उतना ही वो दिमाग में आपका रिटेन होते जाएगा, है ना। सो वी विल कीप 80 to 90% इन इंग्लिश। हेलो सीए फाउंडेशन स्टूडेंट्स, वेलकम वेलकम वेलकम। अगर आप परेशान हो कि मैम अभी सब तैयारी हो गई है लेकिन जो कॉन्ट्रैक्ट एक्ट है ना उसके लिए थोड़ा सा हमें कॉन्फिडेंस नहीं आ रहा है, तो लग रहा है कि कॉन्ट्रैक्ट एक्ट अगर हम लोग लीस्ट पॉसिबल टाइम में कर सकते हैं और उसके साथ साथ हम लोग पूरा का पूरा जो टॉपिक है हर कोई टॉपिक को कवर अगर कर सकते हैं इन द लीस्ट पॉसिबल टाइम, तो ऐसा कोई वीडियो बना दो। बस उसी के लिए मैं आज आपके सामने हूँ। वी आर स्टार्टिंग विद द कॉन्ट्रैक्ट एक्ट रिविजन, और बिलीव मी ये वीडियो देखने के बाद आपके पास जो नोट्स रेडी हो जाएंगे। मैं जैसे जैसे आपको समझा रही हूँ ये इतने प्रिसाइज नोट्स मैंने बनाए हैं कि आप अगर मेरे साथ साथ लिखते जाओगे ये नोट्स देख के तो आपका भी समरी रेडी हो जाएगा, ठीक है। और वो इतना प्रिसाइज होगा कि वन डे बिफोर एग्जाम आपको इसका बहुत हेल्प मिलेगा, क्योंकि इसमें हमने एक भी कॉन्सेप्ट को छोड़ा नहीं है। एंड अलॉन्ग विद दैट जहाँ पे भी आपका थियोरी क्वेश्चन, डायरेक्ट थियोरी क्वेश्चन बनने का चांस है, वहां पे मैं आपको मेमोरी टेक्निक्स भी दे रही हूँ। देखो रिवीजन तो हर कोई करवा रहा है, तो इस रिवीजन लेक्चर में अलग क्या है, व्हाट इज डिफरेंट इन दिस लेक्चर। सो लेट मी बी वेरी क्लियर क्या अलग है। उसके पहले अगर चैनल के लिए आप नए हो तो सब्सक्राइब कर देना, है ना, और अपने दोस्तों के साथ शेयर करो ताकि उनके लिए ये रिवीजन लेक्चर हेल्पफुल रहे। तो इस रिवीजन लेक्चर में अलग क्या रहने वाला है। सबसे पहली बात, अभी तो मैं आपको हिंदी में एक्सप्लेन कर रही हूँ, बट दिस लेक्चर विल बी ओनली इन इंग्लिश बिकॉज obviously you have to write after all your answers in English, है ना। So we will try to keep as much as possible 80 to 90% of this revision lecture in English because you will have those words on your ears then। आप हर बार ये वर्ड जब मुझसे सुनोगे तो उतना ही वो दिमाग में आपका रिटेन होते जाएगा, है ना। So we will keep 80 to 90% in English। देन दिस इज द शॉर्टेस्ट पॉसिबल समरी। जो समरी मैं यूज करने वाली हूँ ना, मुझे नहीं लगता है आपको किसी ने भी इतना शॉर्टेस्ट पॉसिबल वे में समरी दिया होगा कोई भी चैप्टर का, और स्पेशली कॉन्ट्रैक्ट एक्ट का। हार्डली 5 to 7 पेजेस में हमने हर यूनिट को यहाँ पे कवर कर लिया है। आफ्टर दैट अगर आपको ये डाउट रहेगा कि मैम अगर आप समरी इतना छोटा दे रहे हो तो इसमें सब कुछ तो कवर नहीं होगा, नहीं भाई, सब कुछ कवर हो जाएगा। ऑल द टॉपिक्स विल बी कवर्ड, किसी को मैंने यहाँ पे स्किप नहीं किया है। एंड अलॉन्ग विद दैट हम लोग सिर्फ कीवर्ड्स पे फोकस करेंगे, और इससे होगा क्या कि आपका आंसर राइटिंग का पूरा तकलीफ सॉल्व हो जाएगा। सो इफ यू आर गोइंग टू लिसन टू मी इन इंग्लिश, इफ यू आर गोइंग टू लिसन टू द कीवर्ड्स एंड दिस इज गोइंग टू हैपन इन द लीस्ट पॉसिबल टाइम, then you decide whether you want to proceed with this lecture or not, है ना। So this is the introduction of our lecture and straight away we are going to start with unit number 1 for your contract act। चलिए, यूनिट नंबर 1 द इंडियन कॉन्ट्रैक्ट एक्ट, नेचर ऑफ कॉन्ट्रैक्ट्स। सबसे पहली बात, अग्रीमेंट वर्सेस कॉन्ट्रैक्ट कौन से सेक्शन में दिया है। देखो डेफिनेशंस कहाँ आने वाली है, एवरी डेफिनेशन विल बी देयर इन सेक्शन 2। सो व्हाट इज द डिफरेंस बिटवीन अग्रीमेंट एंड अ कॉन्ट्रैक्ट। कॉन्ट्रैक्ट मीन्स एन अग्रीमेंट, यस। सो अग्रीमेंट इज द आउटर सर्कल, उसमें एक सबसेट होता है कॉन्ट्रैक्ट। An agreement is what? It is every promise and every set of promises forming the consideration for each other। और आपको क्या करना है, मेरे साथ साथ ये जो आपको स्क्रीन पे दिख रहा है फटाफट आपको नोट्स बनाते जाना है ताकि वन डे बिफोर एग्जाम आपको हेल्प रहे। अग्रीमेंट मीन्स अ promise and every set of promises which form the consideration for each other। So मैंने आपको कोई promise दिया, आपने मुझे कोई promise दिया and it becomes a agreement। I promise to pay you rupees 2 lakh, you promise to give me your car। Every promise and every set of promises which form a consideration for each other, that is nothing but an agreement। But when is this agreement called a contract? This agreement is called a contract only if it is enforceable by law। So the basic thing is we start with offer। First offer, then the acceptance। If the offer and acceptance have a consideration, then it is called an agreement। And contract is an agreement which is enforceable by law। What is the meaning of enforceability by law? That means it can be taken to the court of law if there is any breach of contract, ठीक है। So every contract starts as an agreement, but it only becomes a contract if it is enforceable by law, and that is the reason social or status obligations are outside the purview of Contract Act। What is the social or status obligation? Like the promise given by a father to a son or the promise given by husband to a wife। Believe me, हम यहाँ पे हर चीज कवर करने वाले हैं, even the case laws, important case laws I am going to take for you guys। So what is the difference between agreement and contract? There can be a theory question. Every contract is an agreement, but every agreement is not a contract. Explain, है ना? So meaning, firstly you will write the meaning. What is the meaning of agreement? It is promise and every set of promises forming consideration for each other. And what is the contract? It is an agreement which is enforceable by law. What is the scope of agreement? Whether the scope of agreement is wider or whether the scope of contract is wider. Obviously, as I said, agreement scope is wider and the contract is a narrower scope. It includes social and legal agreements. But if it is a social agreement, it will not be called as contract because only legally enforceable agreements are included in contracts. ठीक है. Then legal obligation. Does an agreement create a legal obligation? It can or it cannot. If it forms a part of the contract, if it becomes a contract, then we can say that it creates legal obligation. Otherwise, an agreement may or may not create legal obligation. But does a contract always creates a legal obligation? Yes. Nature. All agreements are contracts. Is it true? No. All agreements are not contracts, but all contracts are agreements. So I hope you are clear between agreement and contract. Quickly, let us see the example. X promises to pay for his friend's birthday cake as a surprise gift. Is this a contract? No, this is a social agreement, not a contract, because none of the party intended to create a legal obligation here. But when X agrees to sell his bike to Y for rupees 50,000 and B agrees to buy it, this is both an agreement and a contract since it is legally enforceable. ठीक है. So as I have said, I have also given the important note which can come as question. So all contracts are agreements, but all agreements are not contracts. This can come as a theory question. Then coming to essentials of a valid contract. This is given in section 10. And see, I am quoting the sections for you guys. If you remember it, well and good. And if you don't remember it, none of the marks are going to get deducted. But with sections, our memory gets sharper. कि इसमें ये दिया है, यहाँ पे ये दिया है ना? So that is why I am quoting the sections because you will get used to it, है ना? So section 10 talks about essentials of a valid contract. What does section 10 say? All agreements are contracts only if they are made with free consent by parties competent to contract, for lawful consideration, for lawful object, and they are not expressly declared to be void. So 5 to 6 points are given to us by section 10 and these are essentials of a valid contract. Now see, each of the essential we are going to cover in the respective unit, but here we should have the list ready before us. Section 10 has given most of the essentials, but some of the essentials which are required to make a contract, those are not quoted by section 10. Here we have all the list which covers section 10 essentials as well as the other essentials. Like there should be two parties. This is not given in section 10, but can a contract be formed without two parties? No. So that is also covered here. But a few more essentials are also needed for a truly valid contract, and here all the essentials for the valid contract are given. Number 1, offer and acceptance. First there should be an offer and there should be an acceptance, and then it will lead to an agreement if there is consideration. Second, there should be two parties and those two parties should have free consent. What is free consent? We will cover in unit number 3. Intention to create legal obligation. Can a social obligation called as a contract? No, there should be intention to create legal obligation, and that is the reason social or domestic agreements do not intend to create legal relation. Capacity or competency of parties covered in section 11 and 12 we will cover in unit number 3. Lawful consideration, lawful object, there is a list given by section 23 and in somewhere different sections that these are the objects and consideration which are not considered lawful, and that is not allowed. If the consideration is unlawful, it will not be a valid contract. Other than that, the meaning of the agreement should be certain. If the terms are indefinite or vague, it is not a contract. Possibility of performance. An agreement to do an impossible act is not a valid contract, not expressly declared as void. There are different sections where we have the list that these are the agreements which are expressly declared to be void, and we will cover it in unit number 3. Legal formalities. Other than this, if there is any legal formality which is required by that specific act, then you need to follow that legal formality. Like if the insurance contract is there, it must be written. If it is a transfer of immovable property, it should be registered. So respective acts according to the transaction are also to be followed. So these are your 10 essentials. Now what are the case laws which can be asked in this topic? See, for the topic of two parties, that there should be at least two parties, there is a case law, State of Gujarat versus Raman Lal S and Co. What was this case law? Then when the partnership assets were divided among the partners on dissolution, what did the tax authorities do? They tried to treat it as sale, that the partnership is selling its asset to the partners. But is a partnership firm considered different from partners? Does a partnership firm have a separate legal entity? No. So held, since the partners were joint owners, they could not be both buyer and seller of the same transaction, and there were not really two parties to this sale. So the essential of two parties was missing. Second, Balfour versus Balfour. Whenever there is a question of social agreement and specifically related to husband and wife, you can quote the case law of Balfour versus Balfour. What was the case law? A husband promised to pay his wife a monthly amount as maintenance while he was abroad. He failed to pay and the wife could not recover the amount. Why? Because it was a social or domestic agreement and the parties did not intend to create legal relations. Okay, now coming to the next topic, what are the types of contract on the basis of validity? There are 5 types of contract on the basis of validity: valid contract, void contract, voidable contract, illegal and unenforceable contract. What is a valid contract? It has all the essential elements of a contract and hence it is binding and enforceable. What is a void contract? It is a contract which ceases to be enforceable by law. That means it may be valid once, but due to some reasons it became later unenforceable, and that is why we can call it a void contract. Like if there is a change in law, if there is something due to which your product has become illegal, then earlier the contract might be valid, but now the government has announced that the product is illegal to sell and now your contracts become void. Or destruction of subject matter. I promise to sell my house to you, but if the house itself gets destroyed, the contract becomes void. Voidable contract. An agreement enforceable by law only at the option of aggrieved party. Voidable contract will be there in detail in unit number 3, but here let us cover the important points. What is a voidable contract? It is the contract which can be avoided or it can be valid also, but this depends on the aggrieved party. Who is the aggrieved party? The person whose consent was not free can be called aggrieved party. It remains valid unless the aggrieved party chooses to avoid it. Contract can be voidable due to 3 reasons. Either there is absence of free consent, or the promisee prevents the promisor from performing his promise, or the promisor could not perform within specified time. So when does the contract become voidable? In 3 cases. Remember the 3 cases. First, the consent was not free, or second, the promisee prevents the promisor from performing his promise, or third, the promisor did not perform his promise within the specified time if time was essential element of the contract. What is the illegal contract? It is forbidden by law altogether and they are always void, and even the collateral contracts are unenforceable. Next, unenforceable contract. They are good in substance. There is no problem in an unenforceable contract, but it becomes unenforceable because of some technical defect. Like there might be absence in writing, or there is a debt which has become barred by limitation. So due to some technical defect, this contract, when it becomes unenforceable, it is called unenforceable contract. That is, the court cannot now act on such contract. What is the difference between void and voidable contract? 5 differences are there. सबसे पहले meaning बता दो. What is the meaning of a void contract? A contract which ceases to be enforceable. What is a voidable contract? An agreement which is enforceable only at the option of aggrieved party. What is the status about enforceability? Can a void contract be enforceable? Not at all. But can a voidable contract be enforceable? Yes, but only at the option of aggrieved party. So first we saw the meaning, then we saw about enforceability. What is the reason? Why does a contract become void? It can be due to multiple reasons, some of which are change in law, Or second, circumstances which are beyond the control of parties, like destruction of subject matter. What is the reason of voidable contract? We saw three reasons, but one of it you can write, like consent of the party was not free, or the promisee prevented the promisor from performing his promise, or the promisor did not perform his promise within the specified time. Performance. Can a void contract be performed? Not at all. But can a voidable contract be performed? Yes. If the aggrieved party enforces the contract, then it has to be performed. Rights. What are the rights under a void contract? No one gets any rights under a void contract. But for a voidable contract, the aggrieved party has some rights depending on why is the contract voidable. Right? So the aggrieved party can either rescind the contract, or they can claim damages, or they can do both. So these are your 5 differences of void and voidable contract. Now there comes an important statement. All illegal agreements are void, but all void hona chahiye tha yahan pe, but all void agreements are not illegal. Is it true? Yes, because the reason of being void is not always that the object has become unlawful. It can be multiple reasons. So void agreement cannot be always illegal, but every illegal agreement is always void, that is unenforceable. What is the difference between void agreement and illegal agreement? Illegal agreement, as we saw now, always void, but a void agreement need not always be illegal. Nature. Is it forbidden by law? Not necessarily. But is a illegal agreement forbidden by law? Yes. Punishment. Is there any punishment if the agreement is void? If the house is destroyed, will the parties get any punishment? No. There is no punishment for parties. But in case of illegal agreements, the parties may be punished. Collateral agreement, in case of void agreements, may be valid or may be void, depending on whether it is illegal or not. But in case of illegal agreement, the collateral agreements are always void. Example, A contracts with B, a factory owner, to supply 10 tons of sugar. Now before supply, the fire has destroyed the factory and the stock. This is an agreement which becomes void. It was valid before, but later it became impossible due to destruction of subject matter. So this is an example of void agreement. Now, types of contract on the basis of formation. What were these types of contract? They were types of contract on the basis of validity. Now, types of contract on the basis of formation. It can be express, it can be implied, it can be quasi, it can be e-contract. So these are the 4 types if a theory question comes on the basis of formation: express, implied, quasi and e-contracts. Express contract can be orally formed or by writing. है ना? So oral written is termed as express contract. What is the implied contract? It means the contract is arising from the conduct or action of the parties or course of dealings between them. Say for example, here we have, say for example, a coolie in a uniform picks up a passenger luggage without being asked and the passenger allows it. Now this is an implied contract and the passenger will have to pay because by his behavior, by his conduct, he has formed an implied contract. Now there is also special variety of implied contract which is called tacit contract. There are only 2 examples which are given and you will have to remember them. Tacit contract means a contract which is inferred purely through conduct of the parties. Example, withdrawing cash from an ATM. You go to the ATM, you put your debit card or whatever, you enter your account details, you put the PIN. When you put the PIN, by your conduct, you are implying that the bank will give you the money from your account. So withdrawing cash from an ATM is a tacit contract. Or hammer fall at an auction. If the hammer falls, that means the sale is concluded and that is a tacit contract. What is a quasi contract? It is not an actual contract. There is no offer, acceptance or consent between the parties, but the situation is such that the law itself imposes an obligation. And what is the reason? Why does law impose such an obligation on other person? To prevent unjust enrichment. To prevent unjust enrichment. And also this topic is also covered in the further units in detail. What is the e-contract? Very simple. It is formed electronically. So it may be by email or it may be by EDI, electronic data interchange networks. They are also called cyber, mouse click or EDI contracts. Now we have already covered types of contracts on the basis of validity, types of contracts on the basis of formation. Now, types of contract on the basis of performance. On the basis of performance, it can be executed contract or it can be executory contract. Executed contract means the consideration or the act or forbearance has already been performed. Whatever was the promise, that is already fulfilled. Like in case of cash sales, you have already given the cash and you received the goods. It is an executed contract. But what is the executory contract? It means the consideration is a reciprocal promise and it still needs to be performed in the future by one or both sides. So it can be unilateral or it can be bilateral. Unilateral means one party has already performed and the other party's obligation is outstanding. What is the bilateral contract? It means both the parties' obligations are still outstanding. Example, G agrees to tutor H, a pre-engineering student, starting next month, and H promises to pay for the tuitions 1000 per month. Since both the sides are yet to perform, tutoring has not yet started and the payment has not yet been made, so it is an executory bilateral contract. So what did we see till now? We saw what is agreement, what is contract, difference between them. Then we saw the essentials of a contract as per section 10. Then we saw the types of contract, and now we are going into offer and acceptance. What is the meaning of offer or proposal? Given in section 2, clauses obviously I am going to ignore. When one person signifies to another his willingness to do or willingness to abstain from doing something with a view to obtain assent of that other to such act or abstinence, he is said to make a proposal. Repeat after me. When one person signifies to another his willingness to do or not to do something with a view to obtain assent of that other person to such act or abstinence, he is said to make a proposal. So the person making the offer, he is called offerer or promisor. The person to whom the offer is made, he is called the offeree. And once he accepts the offer, he becomes acceptor. So an offer can be to do something, willingness to do, or it can be not to do something, that is negative act, abstinence to do something. There can be a theory question on the next topic. What are the essentials of a valid offer? So there are 9 essentials of a valid offer. ऑफर कैसा होना चाहिए? इट शुड बी कैपेबल ऑफ क्रिएटिंग लीगल रिलेशन. ठीक है, सो रिमेंबर द एसेंशियल्स वी सॉ इन अ कॉन्ट्रैक्ट. Some of those will be repeated here. It must be capable of creating legal relation, and that is the reason a social invitation doesn't count even if accepted. It should be certain. The offer should be certain, definite. It should not be vague. It must be communicated to the offeree. There is a case law related to this which we will see in a while. It must be made with a view to obtain other parties' assent. So when I say I am thinking to do so, that does not mean I am giving you an offer. But if my intention is to get your assent, get your confirmation on that thing, that means it is not a mere disclosure, that then it becomes an offer. But if it is a mere disclosure of intention to make an offer, it is not a valid offer. So what are the essentials? Capable of creating legal relation, certain, definite, not vague, communicated to the offeree, it is made with a view to get the assent of the other person. Can an offer be conditional? Yes, the offer can be conditional and the acceptor will have to comply to the conditions of the offer. If it should not contain a term, the non-compliance of which would amount to acceptance. If I say, I intend to buy your phone for rupees 50,000 and if you do not reply me within a week, I considered as accepted. Is it valid? No. Offer should not contain a term, the non-acceptance of which would amount to acceptance. It can be a general offer that is made to the public at large, or it can be a specific offer. It can be express, it can be implied. It must be distinguished from a mere statement of intention or an invitation to offer or a mere quotation of price. So what are your essentials of a valid offer? Capable of creating legal relation. It should be certain, definite, not vague. It should be communicated to the offeree. It should be communicated with the intention to get the assent of other party. It should not have a term, the non-compliance of which would amount to acceptance. It can be conditional, it may be general or it can be specific, it can be express or it can be implied, and it should be distinguished from mere statement of intention or an enquiry, reply to an enquiry of price or invitation to offer. Now, this is a very important case law, Lalman Shukla versus Gauri Dutt, as I have said, for the point of communication of offer. See what had happened in the case law. Mr. G sent his servant L, that is Gauri Dutt sent his servant Lalman Shukla to trace his missing nephew. And afterwards he announced a reward for anyone who found him. So first he has sent his servant to find the nephew. Afterwards he announced the reward. Now this servant does not know of this reward that is announced. L found the boy while unaware of the reward. He has now found the boy but he does not know of the reward, and later claimed it. Later he is trying to claim the reward. Held he could not claim it since an offer must be communicated before it can be accepted. You cannot accept something that you never knew existed. So communication of the offer is a precondition to valid acceptance. Lalman Shukla versus Gauri Dutt. Next topic, very important, case studies can come. Offer versus invitation to offer. This is exactly what you need to learn, whatever I am displaying here. So make a note of these things. An offer is the final expression of willingness. What is an offer? Final expression of willingness to be bound by it as soon as it is accepted. Whenever I am giving an offer, my intention is if you accept it, I become bound by that offer. But an invitation to offer is only an invitation for others to make offers. The intention is not to get bound by it immediately, which the inviter may accept or reject after further negotiation. The key test is intention. Does the person intend to be bound immediately on acceptance, or does he intend to do something further before being bound? So that is the difference between invitation and offer. Invitation to offer is proposal to negotiate, or it is proposal to invite the other party to make an offer. Offer is the final expression of willingness to be bound as soon as it is accepted. Intention is to be bound by it as soon as it is accepted, but invitation to offers, intention is only to negotiate. It cannot precede before an invitation to offer. First there can be an invitation to offer, so it will always precede an offer, and then the other person will make an offer, and the party who makes the invitation to offer, it is up to him whether to accept or reject the offer. So that is the difference between offer and invitation to offer. What are the common examples of invitation to offer? Like a prospectus issued by a company who is inviting the public to subscribe for its securities. So prospectus is an invitation to offer for the public. Display of goods for sale in window shop. This is the most commonly asked case study. If there is something displayed in a shop and it has a price tag, the shopkeeper is not bound by that price tag. When you go to the shopkeeper with that particular product, then you are making an offer that I want to buy this product at this price. It is up to that shopkeeper whether to accept your offer or not. Advertising an auction sale. When an advertisement is given in newspaper that there is going to be an auction sale of so and so commodity, it means that advertisement is an invitation to offer. Quotation of price sent in reply to an enquiry. If I ask you what is the price of this product and you reply me, that reply does not mean you are offering to sell your product at that price. That means it is an invitation to offer from your side. Harvey versus Facie. If you remember this case law, you can quote it wherever the question is regarding reply to a query for price. One party telegraphed asking the other party, will you sell us bumper hall pen? Now consider this bumper hall pen as a real estate. Telegraph lowest cash price. I am asking, will you sell me your so and so property? Give me your lowest cash price. Other party replied only with the price. They did not say, we agree to sell you. The first party then telegraphed, we agree to buy at that price. They did not say we agree to sell, and these people are saying we agree to buy at that price. But the second party refused to sell. Now what will happen? It was held that quoting only the lowest price was not an offer. It was merely an statement of price, and so there is no contract because statement of price is not an offer, it is invitation to offer. Next example, X picked articles from shelves in a self-service store and approached the cashier. who refused to sell at that price. It was held the display of articles with price tags is only an invitation to offer. It was X who made the offer to buy at the counter, and shopkeeper cannot be compelled to sell if he desires not to sell. So, okay, so this is about difference between offer and invitation to offer. Coming to what are the different types of offer, classification of offer. First, it can be a general offer. That means it is made to the public at large. Anyone who performs the conditions which are given in the general offer, they are considered to have accepted the offer. It is a continuing offer and it can be accepted by anyone until the time it is withdrawn. Special or specific offer is made to a particular person and only that person can accept that offer. Cross offer means when two parties exchange identical offers to one another but in ignorance of each other's offer. Then this does not result in a contract because one offer by the other person for an offer itself cannot be considered acceptance. Counter offer. The offeree accepts but he has changed some terms and conditions. So the offeree accepts but subject to some modifications or variations. This amounts to rejection of original offer, also called conditional acceptance. So counter offer is also called conditional acceptance, and conditional acceptance is not valid. It leads to rejection of the original offer. What is a standing, continuing or open offer? It is an offer which is kept open for acceptance over a period of time. So during this period anyone can accept it. Example, invitation for tender for supply of goods. There are two important case laws related to general offer and specific offer. Let us quickly look at them. Carlill versus Carbolic Smokeball Company. So what happened? This Carbolic Smokeball Company, they gave an advertisement in the newspaper that anyone who used their smoke ball, consider it as a medicine as per the instructions which are given by them, and if that person still gets influenza, then they will give them a reward. Now Mrs. Carlill used their smoke ball and still caught influenza and she claimed a reward. What will be the conclusion? Can Mrs. Carlill claim the reward? Yes, because if she has satisfied the conditions, because it was a general offer, it is considered that she has accepted the offer. Right? So it was a valid general offer and she had accepted it by performing the stated condition, and that is why she was entitled to the reward. So which case law are you going to remember for general offer? It is Carlill versus Carbolic Smokeball Company. But in case of a special or specific offer, remember the case law Boulton versus Jones. What happened in this case? Jones placed an order with Mr. B. हम इसको बी मिस्टर बी बोलेंगे, ठीक है. Jones placed an order with Mr. B. He did not know that the business was already sold to Boulton. Mr. B had sold his business to Boulton, but Mr. Jones wanted to place the order with Mr. B. Now this order went to Boulton because the business was sold to Boulton. Boulton supplied the goods anyway, but did Jones give the offer to Boulton? No, this was a specific offer which was given to Mr. B. Held that since the offer was made to Mr. B specifically and it was a specific offer, there was no contract between Jones and Boulton. Now what is the important takeaway from the types of offer? A counter offer leads to rejection of original offer. Case studies can come on the basis of this point. May 26 पे पूछा गया था. A counter offer leads to rejection of original offer. So once the counter offer is made, the original offeree is free to walk away. He is not bound to accept the counter offer either. So once you have given the counter offer, the original offer is withdrawn automatically. Now we are done with the topic of offer. Coming to acceptance and its legal rules. Again, the definition of acceptance given in section 2. What is the acceptance? When the person to whom the proposal is made signifies his assent thereto. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted, and a proposal when accepted becomes a promise. So this is the definition of promise as well as acceptance. Now there is an important statement which you need to know by Sir William Anson. Acceptance is to offer what a lighted match is to a train of gunpowder. Acceptance is to offer what a lighted match is to a train of gunpowder. So meaning क्या है इसका? Acceptance converts the offer into a promise, and once the offer is converted into a promise, it cannot be revoked. So acceptance is the trigger for an offer, like a lighted matchstick is the trigger for gunpowder. ठीक है. 7 legal rules for valid acceptance. What are the legal rules? सबसे पहले, for a specific offer, acceptance can be given only by the person to whom the offer is made, like the case law Boulton Vs Jones. And if it is a general offer, anyone with the knowledge of the offer and if he satisfies the conditions, he can accept the offer, like in the case of Carlill versus Carbolic Smoke Ball Company. Second, it must be absolute and unqualified. Acceptance cannot be conditional. If the acceptance is conditional, if it is not in the prescribed manner, it is a counter offer. However, if there is a mere variation in language which does not involve any material difference in substance, then it would not be called as conditional acceptance. Like for example, if I say I promise to give you a credit for rupees 1 lakh and pay me 7% per annum for the year. Now if you say I will pay you 7% per annum in 365 days, does that mean you have given a conditional of acceptance? No, you have just changed the language. There is a mere variation in the language, but the meaning has not changed, right? So it is yet a valid acceptance. It is not a conditional acceptance. Next, acceptance must be communicated. If you just think in your mind that I accept the offer, will it form a valid contract or agreement? No. A mental resolve, that is a mental decision to accept which you have kept to yourself, is not acceptance. Next, it must be given in the prescribed mode. If the mode of acceptance is prescribed, acceptance has to be given in that prescribed mode. But if the promisee or the acceptor has given the acceptance in any other mode and the promisor, the offerer, has not later on insisted that I want the acceptance in the specified mode only, then the offerer is deemed to have waived this right. It must be given, acceptance must be given within the specified time, and if no time is specified, it should be given within a reasonable time. Acceptance cannot be considered from silence. Mere silence is not acceptance, but there are two exceptions. Even if the offerer states otherwise, even if the offerer says that if you do not say anything, I will consider it as acceptance, even then mere silence cannot be considered acceptance unless prior conduct shows silence means acceptance. If there was a condition, we will look at an example. अगर ऐसे होता आ रहा है कि आपके कंडक्ट से हमें ये समझ आ रहा है that even if the parties do not speak, it is considered as acceptance, then silence can amount to acceptance, but otherwise mere silence is not acceptance. Then may be given by conduct. Performing the conditions of a proposal amounts to acceptance. That means acceptance can be by conduct also. If you perform the conditions, it is a valid acceptance. Example, N tried to accept M's offer to sell land for 280 pounds. N wanted to accept the offer, but he has only sent 80 pounds with a promise to pay the rest in installments. But was it a condition that you can pay in installments? No. So ideally 280 pounds, if he had sent all in one go, it would amount to acceptance. But because he has changed the conditions of the offer here, this was not an unqualified acceptance, and so N could not enforce this. Next, A asks B to buy his car for rupees 2 lakhs. If B agrees to buy the car subject to a valid RC or book being available. Now if I say I will buy this car only if a valid registration certificate is available, does that mean that I am giving a conditional acceptance? No. If I am expecting a good title of the car, that is not a conditional acceptance, it is a normal thing. So it is a valid acceptance because a valid title is an implied condition in a contract of sale and it does not make the acceptance conditional. Next, X subscribes to a weekly magazine for 1 year. After expiry of the subscription, the company continued sending him and Mr. X continued using it. So by conduct, by implied way, here the acceptance is formed. By continuing to use the magazine, A has accepted the offer and he is liable to pay for the magazine. So what are the legal rules? 7 legal rules for valid acceptance. The acceptance must be communicated to the person to whom the offer is made in case of specific offer, and in case of general offer, you know it. Second, the acceptance should be absolute and unqualified. Third, acceptance must be communicated to the offerer. Fourth, it must be in the prescribed mode. Fifth, it must be given within reasonable time if specified. within that time. 6. Mere silence is not acceptance unless the prior conduct shows so, and acceptance can be implied also. Now, there is a case law of Felthouse vs Bindley. What is this case law? It is on the point mere silence is not acceptance. An uncle offered to buy his nephew's horse, saying, "If I hear no more, I shall consider horse mine." Can the offer have such terms? No. The nephew never replied but privately intended to sell him. Has he communicated his acceptance? No. Held, silence cannot amount to acceptance. There was no valid contract. So I hope the point regarding acceptance are clear. We have already covered now offer, acceptance. Moving on to communication of offer and acceptance. This is the topic where most of the students feel confused, and we are going to make it crisp for you guys. Now we have to divide this topic in two parts. It is communication of offer and it is communication of acceptance. First, when is the communication of offer complete? Communication of offer is complete when it comes to the knowledge of the person to whom the offer is made. जिसको ऑफर किया है उसको जब पता चल जाए कि ऑफर किया है तब communication of offer complete हो जाएगा. Communication of acceptance is complete as against the proposer when it is put into course of transmission, okay, and as against the acceptor when it comes to the knowledge of the proposer. So acceptance में दो point है, as against the offerer and as against the acceptor. As against the offerer, it is complete when the acceptor puts the acceptance in course of transmission. As against the acceptor, it is complete when it comes to the knowledge of the offerer. So a lot of importance is given in time in deciding when the offer and acceptance is complete, but this is mostly applicable in case of postal communication. For offer, it is complete when it reaches the offeree's knowledge. Acceptance is complete as against the proposer when the acceptance letter is posted. As against the acceptor, acceptance is complete when the letter comes to the knowledge of the offerer. So the offerer gets bound by the offer the moment the acceptance is posted. Now even if it is delayed or lost in transit, as long as it is correctly addressed and stamped, the offerer gets bound. But the acceptor gets bound only when the letter reaches the offerer. These timelines are most relevant for offer and acceptance which are made by post. Example, X posts an offer to sell his house on 10th March. Y receives it on 12th March. The offer is communicated on 12th March. Why? Because Y has received it on 12th March. When is the communication of offer complete? When it comes to the knowledge of the person to whom the offer is made. So it is complete on 12th March. Y posts his acceptance on 14th March. So when is the acceptance complete as against Mr. X? 14th March. It reaches X on 17th March. He reads it on 18th March. So as against Mr. Y, when is the acceptance complete? It is on 18th March. X becomes bound on 14th March, the day when he posts the acceptance letter. But Y becomes bound only on 18th March when the offerer, that is Mr. X, has the knowledge of the acceptance. So this is about communication of offer and acceptance, but mostly all these complications are there in the case of postal communication. If there is instantaneous mode of contract like phone, telephone, email, the contract is complete only when the acceptance is actually received by the offerer and not when sent. Because what we have seen in case of postal communication, the offerer gets bound by the offer once the acceptor communicates his acceptance, once he has sent his letter. But in case of instantaneous modes of communication, there is a contract only when the acceptance is actually received by the offerer. Now there is a small topic of communication of special conditions. Special conditions must be communicated to the other party before or at the time of entering into contract. If the special conditions are not communicated before or at the time of making of the contract, then acceptance of such condition will not be valid. But if it is communicated, then it can be valid contract and it is called tacit or implied contract. Example, conditions printed on a ticket. On the back of your ticket, there might be some conditions written. Even if they are in fine print, they can be binding if they were reasonably communicated or displayed to the passenger at the airlines, right? However, the condition must be reasonable. Second, a customer accepting a laundry receipt containing special condition is generally treated as having tacitly accepted those conditions. However, if the conditions are unreasonable, then they are not binding. In this case, the customer could recover the full value of the sari. So these two examples are based on a case law. This you can remember for the topic of communication of special acceptance. Second point, a standard contract can bind a party even if they have not actually read the terms, provided reasonable notice of the terms was given, as we saw in the first point. If the document does not reasonably indicate that it contains special condition, the conditions are not binding. If the special conditions are communicated after the contract are made, then also they are not binding. Hope this summary helps, because in module it is very confusing. Example, a transport carrier introduced liability limiting condition. So say I am the transport carrier, you have given me your goods, and what I am saying, if anything happens to the goods, now I am not responsible. But did I say it before? No. I am saying this after the contract is made. So in this case, he is saying so after accepting the goods. Since the conditions were not communicated before the contract, they were not binding on the owner. So this is the topic about communication of special conditions. Now, communication of performance, a very small point, and this is based on the case law of Carlill versus Carbolic Smokeball Company. Normally, acceptance must be actively communicated, but where an offer is made as a promise in return for an act, like we said, use our medicines, and if you get influenza, even if after using our medicines, we will give you a reward. Simply performing the act is enough. The offeree need not separately announce, I accept, and performed. Mrs. Carlill need not separately say that I accept your offer. When she is using the medicine as per the directions given by the company, that means she has accepted the offer. So Carlill versus Carbolic Smokeball Company established three principles. An offer must contain a definite promise to be bound if its terms are met. Second, an offer can be made to a specific person or to public at large. Third, if the offer is a promise in return for an act, simply performing that act even without communicating is treated as valid acceptance. So this is something different from the point that acceptance must be communicated, right? So this is like an exception to the general rule, acceptance must be communicated. It is used whenever a question involves rewards or public promise, like in case of Carlill versus Carbolic Smokeball Company. Now we are done with communication of offer, acceptance, communication of special conditions, then performance of offer, revocation of offer and acceptance. When can an offer be revoked and up to what time can an acceptance be revoked? A proposal offer can be revoked at any time before the communication of acceptance is complete as against the offerer or the proposer. So offer can be revoked till the time the letter of acceptance is posted by the offeree, right? An acceptance can be revoked at any time before the communication of acceptance is complete as against the acceptor. So acceptance can be revoked any time before the letter of acceptance reaches the offerer. Revocation of offer or acceptance is complete as against the person who is making the revocation whenever he puts that letter into transmission, and as against the other party when it comes to his knowledge about the revocation. So an offer can be freely withdrawn anytime before it is accepted, even if the offerer had originally promised to keep it open for a specific period. Even if it is a standing offer, until the time it is accepted, anytime it can be withdrawn. Under Indian law, even acceptance itself can be revoked. This is the difference between Indian law and English law. As long as the revocation reaches the offerer before or at the same time as original acceptance letter. So if the revocation letter and acceptance letter reach at the same time, revocation will be considered valid in Indian law. Now the last topic for today, what are the 7 modes in which offer can be lapsed or offer can be revoked? First is by giving the notice. I specifically say that I revoke the offer. That is by notice of revocation. Second, by lapse of time. If acceptance is not given within the specified time or within reasonable time, offer lapses. So first is by notice of revocation. Second is by lapse of time. Third, non-fulfillment of a condition precedent to acceptance. If there was a condition given with the offer and if that condition is not fulfilled, acceptance is not valid, the offer is revoked. by death or insanity of the offerer. So there is automatic revocation in case of death or insanity of the offerer, but this automatic revocation applies only if the fact of death or insanity was known to the acceptor when he accepted the offer. If I knew that the offerer has died, then I cannot give the acceptance. The offer is considered as lapsed. There is automatic revocation. So what all points we have seen in revocation of offer? It can be by notice of revocation, lapse of time, non-fulfillment of a precedent condition, death or insanity of the offerer, and last 3 points by a counter offer, that is by a conditional acceptance the original offer stands revoked, by non-acceptance in the prescribed or usual mode. So if I had stated the mode of acceptance and you did not give in that mode, the offer is revoked. By subsequent illegality of the subject matter, also the offer can be automatically revoked. So these are the 7 ways of modes of revocation, or the modes in which offer can be lapsed. Here are a few examples. A proposes by a letter sent by post to sell his house to B. B accepts the proposal by a letter. A may revoke his proposal at any time before the letter of acceptance is posted by B, but not afterwards. B may revoke his acceptance any time before or at the time when the acceptance letter reaches A, but not afterwards. A person applied for shares in June, but the company allotted them in November. Now, due to lapse of time, the offer had lapsed, and since the acceptance came very late, there was not a valid contract. A offers to sell his house to B for rupees 5 lakh, provided B leases his land to A. So there is a condition attached to the offer. If B refuses to lease the land, then the condition is not fulfilled. Then A's offer is automatically revoked because the condition precedent was never fulfilled. So that is about the 7 ways in which offer can be revoked with examples. We are done within an hour of a very effective revision of our Unit 1 of Contract Act. Keep revising, keep studying.